not otherwise. So, we are discussing electronic record 65A and 65B. So, here it says, notwithstanding anything contained in this act, before or after, any information contained in an electronic record, then plus, which is printed on a paper, stored, recorded, copied in a magnetic media, produced by a computer called computer output, shall be deemed to be a document if the conditions mentioned herein below are satisfied, and the information and the computer in question, and shall be admissible in any proceeding without further proof for production of the original as evidence of any contents of the original or any fact stated therein of which direct evidence is admissible. Wherever direct evidence is required, if you produce something that is produced by a computer, it will be admissible. Now, second, 65B2. The conditions referred to in subsection 1 in respect of a computer output shall be in the following, namely, A. The computer output containing the information was produced by the computer during the period over which the computer was used regularly to store or process information for the purpose of any activities regularly carried on over that period by the person having lawful control over the use of computer. What does it say? It says number 1, computer output plus information plus the computer was regularly used to store and process such information plus it is given by a person having lawful control over the computer. These are the 4 things that are given under A. Now B. During the said period, information of the kind contained in the electronic record or of the kind from which the information so contained is derived was regularly fed into the computer in ordinary course of said activities. Now there is one additional link that is given here. Everything given in A plus it is the information is regularly fed into the computer in ordinary course of the business. In ordinary course of the business, that's the important point under B. Now see, throughout the material part of the said period, computer was operating properly, and if not, then in respect of any period in which it is not operating properly or was out of operation during that period was not such as to affect the electronic record, the accuracy of its content. So we are producing a particular electronic record. Here in the C part, they are talking about the computer itself being in a running condition. Now if it is not in a running condition for any particular period of time in between, for some period, 1 day, 1/2 day, 2 hours, then such out of work, out of operation period does not affect or has not affected the record that you want to access from the computer. That is the third thing, C. Now D, the information contained in the electronic record reproduces and is derived from such information fed into computer in the ordinary course of the said activity. What you feed in is numbers. What you bring out is the information. What you feed in is data. What you bring out is a report. Okay? So what he says is, it is that particular record, the information that you bring out, that is the computer report that you get out of it, is derived from that data that is fed into the computer in the ordinary course of the business. Now, 3. Where over any period, the function of storing or processing information for the purpose of any activities regularly carried on over that period, as mentioned in clause A of subsection 2, was regularly performed by computers, whether is regularly, the word important is regularly, functioning regularly, doing regularly, activities regularly, performance regularly. That's all 3 is. Now, whether by a combination of computers operating over that period, by different computers operating in succession over that period, by different combination of computers operating in succession over that period, or in any other manner involving successive operations over that period. Now here this A, B, C, D, what do you mean? What do they say? They only say that maybe you are using laptop Lenovo for some time, then you are doing that Lenovo, you send it out, brought some other thing, Lenovo Dell you use, then later on you use Windows laptop, then you use Google laptop, but all the 4 laptops are a continuing option of the same data being fed and then the same report being generated. That regularly being done in the normal course of action, even though the computers themselves have been changed. This is what it says. 3. Now 4. In any proceedings where it is desired to give a statement in evidence, by virtue of this section, a certificate doing any of the following things that is to be given. Now, this is the most important part. 65B4. 65B4 is the most crucial and crux of the entire section. What it says is, in addition to the statement, in addition to the report that is being submitted to the court as a computer output from all these computers that are regularly in the course of action, in the course of business are being maintained, are being fed and report being generated, then a certificate has to be attached. Now, what is this certificate? It says it identifying the electronic record. You should say, the certificate should say, yes, I am submitting this electronic record, this statement generated from this computer output, containing the statement describing the manner in which it is produced. It is produced on Canon printer so and so, or it is fed into one pen drive, identification so and so, put in hard disk so and so, put in CD so and so, like that, with identification, giving such particulars of any device involved in the production of that electronic record as may be appropriate for the purpose to show the electronic record produced by a computer. Now, dealing with any of the matters to which the conditions mentioned in subsection 2 purporting to be signed by a person. Now, this particular certificate has to be signed by a person. A person has to, see, remember always one thing, a letter has its value only by the signature of the person who is signing it. A letter without signature is no letter. A certificate without signature is no certificate. So, a person occupying a responsible official position in relation to the operation of the relevant device or management of the relevant activities shall be the evidence of any matter stated in the certificate. The certificate will be proof of the contents of as well as the document. Will be proof of the document as well as the contents, if it is given by a particular person occupying a responsible official position in relation to operation of the computer. So, and for the purpose of this subsection, it will be sufficient for a matter to be stated to the best of the knowledge and to the belief of the person stating it. So, when the certificate, what do you mention? To the best of my knowledge and belief. How do you make the certificate? You say to the best of my knowledge and belief. Okay? I being a person responsible for the operation of this computer and management of this computer, give the following certificate that this computer output has been generated in the normal course of business of the data being fed into my computer and the output being received, and this is being submitted to you as evidence for this particular purpose. This is how the certificate should be there. And the purpose of this section, information shall be taken to be supplied to a computer if it is supplied thereto in any appropriate form, any input form, and is so supplied directly with or without human intervention by means of any appropriate equipment. It can be human intervention, that is you type it out, or it can be fed through internet or otherwise. Whether in the course of activities carried on by the official information is supplied with a view to it being stored or processed. Here importance is stored and processed for the purpose of these activities by computer operated otherwise than in the normal course of business. That information, if duly supplied to that computer, shall be taken to be supplied to it in the course of those business. A computer output shall be taken to have been produced by the computer, whether it was produced by directly, with or without human intervention, by means of appropriate equipment. For the purpose of this section, any reference to information being derived from other information shall be a reference to it being derived therefrom by calculation, comparison, any other process. So, what is algorithmic process? What the computer will do? Algorithmic process, that means you feed in data, the computer will put its algorithmic process and bring out a computer statement, and that is either given in a CD form or a pen drive or a statement, and it is attached with the certificate from the management head of that particular computer saying that I, to the best of my knowledge and belief, and I am the owner or I am the manager of this particular computer resource, and this computer report that has been generated is based on the data that is fed into my computer in a normal course regularly without fail, and then this is derived and this is submitted to you for evidence. So this is how the certificate should be there. Now, the two major cases that are discussed in this particular case, two names you have to remember. One is PV Anwar case. This is non-obstante clause. This is non-obstante means notwithstanding anything from 62 to 65. 65A and 65B will prevail. In Indian Evidence Act, this PV Anwar case, they have clearly mentioned that non-obstante clause that is given in the section, that is notwithstanding. It means that all the earlier process, all the earlier provisions, all the earlier rules under Indian Evidence Act 62 to 65 are not applicable or superseded by 65A and 65B. And second case is Arjun Pandit Rao case. It is also the same thing and with some details as to who should give a 65B certificate, where any concessions are to be given or not. Now, Indian Evidence Act 65A says e-record shall be proved via 65B. That's all. 65A, what does it say? It says e-records, electronic records shall be proved via 65B. Now, what 65B says? A certificate plus admissibility as an exhibit plus no proof of correctness and of contents of the document. But here, one small thing is that the contents of this 65B certificate, in the Arjun Pandit Rao case, it was clearly mentioned, but Supreme Court has clarified that it is a certificate which will ensure admissibility as an exhibit. It will ensure admissibility as a document, but it does not prove the contents of the document. That means, supposing you are a banker, you are giving a statement of account. That statement of account will be, with the covering certificate, will be admitted as an evidence, but the contents of that will not have any proof of as to the contents of it. That means, if there is something, let's say you are being tried under PMLA, Money Laundering Act, that means it doesn't prove the contents, either prove the money laundering or otherwise. This money laundering part of the contents of that statement have to be proved by you elsewhere, differently. That's what it means. So, just by producing a 65B certificate, you can say money laundering has been proved. That you cannot say. Document has been produced, statement of account has been produced, only that much you can say. Okay? And document per se will be proved, will be admitted, not the contents are proved. Now, independently, you have to prove the veracity of the contents of documents. Now, in a particular case of Shafi Muhammad, Supreme Court has held that the requirement of producing a certificate under 65B4, remember this section, 65B4, is procedural and not always mandatory. Some concession has been given by Supreme Court here saying that this is a procedure but not mandatory. There is, in case of any exceptional circumstances, exceptional hardship, in the interest of justice, then you can always, the court has the option to give it a go by. A party who is not in a possession of the device from which the document is produced cannot be required to produce the certificate under 65B4. Court was of the view that the procedural requirement under 65B4 is to be applied only when electronic evidence is produced by a person who is in control of that device, therefore in a position to produce such a certificate. If a person is not in possession of the device, 63 and 65 cannot be excluded. That is the decision. So, Supreme Court decision, this particular decision is overruled Tommaso Bruno and Shafi Muhammad and clarified the position. Next case. A certificate under 65B4 is mandatory and a condition precedent to the admissibility of evidence by way of electronic record. This was laid down in Anwar case. Need not be revisited. However, the last sentence in para 24 says, if an electronic record as such is used as a primary evidence under section 62, the same is admissible in evidence without compliance of 65B. Supposing you want to produce an electronic record, a movie made by your cell phone. If you produce the cell phone itself along with the movie, then it is eligible under 62 as a primary evidence. So you don't have to produce any 65B at all. But if you want to give only the movie by way of a pen drive, okay, then 65B is necessary. Right? That's the difference, please remember. A non-obstante language and 65B1 makes it clear that when it comes to information contained in that electronic record, admissibility and proof thereof must follow the drill of 65B. That means 65B, first is 62, if it is primary evidence is there, you give the entire cell phone, or 65B, you have to produce a certificate and a movie itself, video itself in a pen drive. Then you have to go through that 65B certificate also. The requirement under 65B4 is unnecessary. Again, if the original document itself is produced, this can be done by the owner of a laptop computer giving the laptop, by the owner of the tablet giving the tablet itself with the movie, or even a mobile phone by giving it to the mobile phone and stepping into the witness box and saying, proving the concerned device as well as the contents. It is owned and operated by him. You have to tell him that I own it, I operate it, and just got this movie, and this shows this particular thing. I have witnessed it, I have shot that. These are all things you have to say in the witness box. Then under 65.2 it will be admissible. 65B4 will not be necessary. Where the computer happens to be on a system or a network, you can't pull it and give it in a court. It is impossible to physically bring such system or a network to a court. Then the only means of providing information containing that electronic record is in accordance with 65B1 together with certificate under 65B4. Oral evidence cannot suffice in place of a certificate of 65B4 and even L&A cannot be given by a person in charge of a computer device in place of the requisite certificate under 65B4. Now, here you cannot give a go by unless it becomes very, very difficult, and in spite of all good efforts, he is unable to get the certificate. Where the requisite certificate has been sought from the person or the authority concerned, and the person or authority concerned refuses to give such certificate or does not reply to such demand. Supposing a movie is there in YouTube, okay, you write to YouTube, give me a certificate. You only download the YouTube video and you write to YouTube asking for a certificate. There is no reply from YouTube. What do? Then you write registered post and attach to it, give this movie and give the link URL, submit to the court. The party asking for such certificate can apply to the court for its production under provisions of Evidence Act, CPC or CRPC. Once such an application is made to the court, and the court orders and directs the requisite certificate to be produced by the person to whom it sends summons in this regard, that means the court will send a summons to YouTube. The party asking for certificate has done all that he can possibly do. That is meant you have done your efforts. You even approached the court. Court has also issued a summons. Nothing has come out of it. Then forget about 65B4. The court observed that 65B does not speak of the stage at which stage such a certificate must be furnished. So the second stage is when you have to give this certificate. At the time of plaint, at the time of complaint, at the time of starting the trial, at the time of police report. When is it? It says any time before judgment is made. Any time before judgment is made, because 65B does not say any particular place, a time or a stage at which it is to be given. So in Anwar case, the court did observe such a certificate must accompany the electronic record when the same is produced in evidence. But this requirement is applicable in cases where such certificates can be procured by the person seeking to rely on the electronic record. In case where either a defective certificate is given or certificate is demanded and not given, the court must summon the person under 65B4 and require the certificate to be given to the court. This ought to be done when the electronic record is produced in evidence before the court without the requisite certificate. In criminal cases, however, the requisite certificate can be directed to be produced by the court at any stage as long as the trial is not over. While these observations were made in the context of criminal cases, the court noted that the aforesaid is subject to exercise of appropriate discretion in civil cases also. Because it has been found that it is becoming very, very difficult for people to get the 65B4 certificate from the owners of the computers which hold these particular records, which are useful, which are to be given in their particular case. Given that the certificate under 65B4 may be given long after the electronic record is actually produced by the computer, it is sufficient that the certificate is either to the best of the issuer's knowledge or belief. This is to the best of my knowledge or belief, this certificate is given and the record has been produced 4 months before, but still nowadays I don't have it, I cannot verify it, it's the same thing, but still to the best of my knowledge and belief, this is true, that certificate if they give, that is sufficient. Now conditions under 65B2 and 65B4 must be satisfied cumulatively. In addition to that, Supreme Court has issued general directions to cellular companies and internet service providers. These are all the middle people who run between you and the data itself, to maintain call detail records and other relevant records for the concerned period in a segregated, secure manner if such record is seized during investigation in the relevant period. Supposing a crime is reported, and for the crime the police go and seize the records. Then the court has issued, Supreme Court issued a direction to these service providers and cellular companies, you please segregate the details and keep them till the case is going on. Don't say that after 3 months, after 1 year, after 6 months, as per our rule, we have destroyed it. No, don't destroy it. Keep it aside. If it has been seized, the police give a letter that we are seizing this particular relevant data. Then you also take it out, this particular record, original record, and keep it separately. Segregate, archive it separately. That till the case is over, till the case appeal is over. Once the appeal is over, then you can destroy it. That's the rule given by Supreme Court. If such record is seized during investigation in the relevant period. Now, concerned parties can then summon such record at the stage of defense evidence or in the event such data is required for cross-examination of witness. So, if they keep separately and archive it separately, what is the benefit? The benefit is that they can be called for in the court either for defense or for cross-examination or for re-examination and things like that. Now, Supreme Court clarified that these directions must be followed by the courts that deal with electronic evidence to ensure preservation of such evidence and the production of a certificate at the appropriate stage. The court found this necessary given that telephone and internet service providers are required to preserve and maintain electronic or internet log records for only limited period of 1 year. If the police or other individual fail to secure those records within one year, or secure the record but fail to secure the certificate within that 1 year, then the production of a certificate issued after the trial would all probability render the data unverifiable. So in order to allow for the verification till the case is over, because our cases go on for 10 years, 20 years, we don't God knows what. So an accused seeking to challenge the genuineness of a certificate under 65b4 would be prejudiced. So the cell phone operators or the internet service providers have to maintain, to archive the data, whatever has been called for by the police for a period till the case is over, till 10 years, what, even if it is 10, 20 years, doesn't matter. But it is a limited data only, you keep it. Supreme Court was of the further view that appropriate rules and directions should be framed under IT Act 2000, including for retention of data involved in a trial of offences, their segregation, rule of chain of custody, stamping, record maintenance for the entire duration of the trial, as so plus appeal, and also in relation to preservation of the metadata to avoid corruption. So here they have said two things. One, data itself, in addition to data, the metadata also, because if you want to verify the data, the metadata is very, very crucial. Audit trails are very, very crucial. So these things have to be maintained in addition to the data itself. So appropriate rules for preservation, retrieval, production of electronic records should be framed. They are not framed, it is to be framed. Okay. So this particular recommendation is given by the Supreme Court to the government. Now a computer, let's just say one case. Let us see the one case and then the cross-examination. A computer is apparently used by a person for making certain searches and downloading certain files. That's what we do normally with a computer. This information is used to corroborate the charge against the person. In a case where the hard drive is seized by the police, let us say it is a murder charge. It is a murder charge and it has been, a person is charged against it, and then there is information on the computer. This is a CCTV footage, and CCTV footage is recorded in the DCR. So then that record is there from this particular time to this particular time. It is there to corroborate the charge against the person. In a case where the hard drive is seized by the police from the computer and not the computer as a whole, only the hard drive is seized without assistance of the forensic expert. Here one small twist. The twist is they did not call for a forensic expert while taking out the data or taking the hard disk or seizing the hard disk. They have done it on their own and has been given to the forensic expert for analysis at a later date. I mean, you choose to seize it on day 1 and you hand it over to the forensic experts on day 30. There is a gap of 30 days and there is no, in between these 30 days, what happened to that content, nobody knows. So your client believes that you are from the defense side and your client says, Bhaiya, it is true that is shown here that I was present from this time to this time for 15 minutes. But actually I was there for 15 minutes only. That man was there for next 1 hour and his death occurred after I left him. After I left him, hale and healthy in that particular place. Whereas the police is not submitting, it is submitting only 15 minutes recording. It is not submitting 1 hour recording. So when he says so, you will have to bring out that this 1 hour recording has not been produced before the court in a cross-examination. Let's see this how it comes out. And not the computer as a whole, it is not seized. Without assistance of a forensic expert, and has been given to forensic experts only for analysis. Your client believes, this is the accused, that some data is tampered or lost during its handling. Such a destruction can be deliberate or inadvertent. It has been seen many times that the police, due to some of their own reasons, and PP is also due to some their own reasons, they do not present all the data to the court. They will present only that part of the data, a portion of the data that support their contention, that support their charge. So if this charge is driven home, it would attract a penalty under 204 IPC, can attract adverse inference under 114 G of Indian Evidence Act, in addition to other repercussions for willful destruction of evidence. So this has to be brought out by the defense lawyer. Now let us see how it is done here. The cross-examination of such custodian or expert who has examined the records can look as follows. What does it say? First question. Can you tell why have you used the word summary of the report in your report? He says, because the report is supposed to be a summary, If this is the summary, next question, then can you show where is the entire report? No, this is the only report I have. Will it be correct to say that a summary of the report cannot be prepared unless there is a full report in anybody's custody, in your custody? And it says, after referring to the relevant part of the report, you read out from the report. Can you tell me what steps did you take to protect the original hard drive? The expert describes the methods. If they are not forensically sound, then the methods can be attacked. An attack on his expertise also can be launched. Now, next question. One of the ways to verify the original hard disk has not been tampered with is a hash value. So you ask the question, did you prepare hash value of the data before acquisition? No, sir. Will it then be correct to say that you did not have any material to verify the hash value of the data post-processing? Because you see, after processing, before processing, after collection, before collection, hash value has to be collected. And hash value has to be calculated to show that no material evidence has been lost, no tampering has been done. This particular thing he has not done. Why? Because he was not given the entire hard disk by the police, and that too police have recovered from the seized from the site, but they have taken a lot of time to give it to him. So this hash value has to be calculated just at the time of seizing, and then that has to be compared at the time of post processing. Only then can it be said that the entire period in between the point of seizure to the point of production to the court, the thing has not been tampered with. So here the hash value is the importance of the hash value. The court will be asked later to discard the evidence in the hash value comparison to authenticate the contents. Not tampering is not carried out. So then what the fellow will say, no, I did not see that. Did you look for it? No, I was not asked not to. I was told my boss, mat pucha yaar, jaan do. Could you have done it if you are asked? Yes, definitely. Is it possible that the data that was handed over to you for forensic analysis was selective data and not the entire data that was there on the hard disk? Is it possible? Yes, sir, it is possible. Did you not insist for the original hard drive? No, I need not. Do you know who removed the hard drive from the computer? No, I do not know. Is it you? No. Is it forensic officers? No. Who are they? No, sir, maybe police have removed. So, instance of 65B, that's all. So, this is the question. This is the cross-examination. Now, at the result of the entire cross-examination, what has come out? What has come out is that, number one, see how it has run. First is, you are a defense fellow, and then your case is of a murder. Okay, the person who has come to you says, I did not commit murder, sir. Then the PP has put up a show saying that this person was last seen with the deceased at this particular hotel in this mall from this 6 o'clock to 6:15. He died, the time the postmortem says he died between 6 to 7 p.m. The postmortem says he died between 6 p.m. to 7 p.m. And then the PP produces a CCTV footage saying that from 6 o'clock to 6:15 this man was there with the deceased in a hotel in a mall. Okay? So this was presented. So that is a very, very damning evidence, and this fellow will really be hanged to death because he is the last person to be seen with the deceased, and it was also proved that he was there during the correct period in which the death has occurred, because when the postmortem report is submitted, they give a possible time before the postmortem period, that is 3 to 4 hours before postmortem is done, 1 to 2 hours before postmortem is done, that means 6 to 7 o'clock on that day. So on that day, 6 to 7 o'clock, murder has happened. That is what the postmortem has done. So now your client is now really in a very bad situation. He is fixed for good. So in order to get out of that situation, so what do? You should know that how do you essentially, what are the mistakes that can be made? Who are the persons who are competent to take the hard drive? Who are the persons who are competent to use the material? And then who are the persons, what is the chain of custody that is followed? You have to understand chain of custody requirements. Then you have to understand what process is done in the forensic laboratory. You have to understand what the expert will do, what kind of an expert will do, what are the 4 things that will do, how do you protect the hard disk, take a bit by bit copy, then put it to process, then arrive at your analysis, whatever your analysis you want to do, then give a report. These are the 4 or 5 things that it does. So, but he has to authenticate and ensure that no tampering has been done. No tampering has been done. How will you ensure? He will ensure that you should know that it is ensured by way of a hash value. When does the hash value is calculated? It is calculated at the time of seizure, number one. Second, at the time when it is given to the forensic lab. Number two, at the time of post-processing, when a report is generated and sent back to the court. These three hash values will be there. If these three hash values are the same, then it is ensured that this particular whatever instrument, whatever hard disk is there, has not been tampered with. But unfortunately, because the police fellow has taken that hard disk, has seized that hard disk without asking for help from the forensic fellow, he did not know about hash value. How to calculate hash value, he had no idea. Hash value to be taken, he had no idea. Chain of custody has to be maintained, he had no idea. So because of that, this particular issue has happened. So in order to bring out this particular fact, you have to ask these questions in this particular angle. What all he said? He has caught one word, one phrase, summary of the report. He says, I have seen or I have observed so much, 15 minutes of hard disk, 15 minutes of CCTV. That's what he says. And a summary of the report, what I have observed from that is given here. So immediately it should strike you. So this fellow is saying only this much time and also saying summary of the report. So he caught hold of that, the defense fellow, and started hammering on that summary of the report. Why did he not say full report? Why did he not say only part report? Why did he say only summary report? If summary means it is only part. If summary means then the original should be there. Is the original with you? Did you check the original? Did you check the original for not being tampered with? So next, question after question after question. Finally, the hash value did you calculate? Do you know that hash value should be calculated? Did you calculate before taking the hard disk? Did you calculate at the time of seizing? Who seized it? Then at the time of post-processing, who had done the processing? So these 3-4 things that will come out. So this particular case in a court will finally nail the lie of the public prosecutor and the police, because the police and public prosecutor, they tried to hide what is beneficial to the accused, and then they'll put forward only what is harmful to the accused so that they will win the case. So this is what happens in India because we have an adversarial system on with us. Okay? Now, next question is, if 65B is so important. Okay, now instances where 65B need not be produced. What are they? Now first, CCTV footage stored directly on a hard drive of a computer being self-generated without human intervention. Remember this word, self-generated without human intervention. It becomes the primary evidence. It is not secondary evidence. If it is a secondary evidence, 65B for certificate is required. But the primary evidence, 62 is sufficient. Just produce it. But if there is same footage was further copied or reproduced onto a pen drive or a CD, then it would require 65B certificate. It will become a secondary evidence. Next, if the IO tapped a phone conversation between two accused and then recorded their plan to demand ransom money and dispose of the dead body. This phone conversation between the accused leads to unearthing of a material evidence also, that money has been recovered or the dead body has been recovered or the instrument which was death has been caused is recovered, any material evidence. The case is treated as a primary evidence. No 65B is required. Next, a husband sought to produce a video clipping of his wife's having an affair with a third person through a spy camera or a pinhole camera. The wife says, no, this is privileged communication between husband and wife in their bedroom, so you cannot show it in the court. But the court said, this is essential to the case and this is essential to establishing extramarital affair, and it is a clipping from the hard disk of the pinhole camera. Therefore, it becomes a primary evidence. 65B is not necessary because wife being the owner, wife will never give 65B certificate. No. So, next question. Persons who are competent to issue the certificate under 65B. Now, what are the next very big issue is that who is the person who has to give the certificate under 65B? What is the certificate? What is the section say under 65B? It says those persons who have the management control, who have the ownership of the issue, ownership of the computer, or under whose control and supervision the data is fed and report is generated at the relevant period of time. These are the persons who are competent to give certificates under 65B. Now, who are such persons legally entitled to give such certificate? Is number one, director of a company or a CEO of the company of which the computer is used, in which the computer is used. First fellow. Next, computer operator or a device operator from which the electronic evidence is generated. That's the second part. Third fellow, the department manager or HOD, head of the department, where the computer is used. Next, a security officer of the DVR camera system or a CCTV camera system under whom the security cameras are running and computers are kept in his office. That fellow can give. He is also competent to give certificate. Owner of a mobile phone or a user of a mobile phone from which the photo or a video is taken, he can also give a certificate. Then officer of the mobile phone company who provides the call data records or IP detail records to the government or to the police, he can also certify. Accountant or accounts manager who generates a ledger or account statement in electronic form, submits the printout for the purpose of evidence, he is also. Now, in one particular case, 2015 Goa bench of the Mumbai High Court, it says a certificate under 65B, which was signed by a person who was not in a responsible official position. Remember this, responsible official position. Many times what happens, these defense people, they go and bribe the lowest clerk or a peon, and that fellow will bribe some other clerk or a peon, and that fellow will take out a call data record and then hand it over without any signature or anything. So that will not have a certificate. So later on they ask for a certificate. By the time the court asks for a certificate and that fellow gives, because this fellow has not procured it by right means, he has procured it through wrong means. But unfortunately in Indian law, whatever be the means with which you produce a document, it is the document, if it is relevant, is accepted. Okay, even if it is stolen also, it is accepted. So in such a situation, when you ask for the fellow officially through the court, then ask for it, then he says, we have already destroyed, no certificate will be given. So in such a situation, what he says, was not in a responsible official position. He'll say the clerk or that peon will sign that I have given, but that is not valid. In relation to he is not in an official position in relation to operation of the computer of the complainant, and was not author of the log sheets or invoices, and had no free access to the computer, then he cannot issue such a certificate. Even if he issues, it is not valid. So in a cross-examination, you can always prove or disprove the certificate from being introduced. Now the requirement can be relaxed by a court. Here it is mandatory for the production of electronic evidence. However, it is unnecessary when the document itself is produced. When the entire hard disk is produced, the entire document is produced, then it is not required. Justice Nariman, if you have a chance to see YouTube, a lot of lectures are there by Justice Nariman. He is supposed to be the new era judge of Supreme Court. New era judge of Supreme Court with lot of soft corner for the commercial capital of Bombay. He is from Bombay. So he has given lot of judgments in favor of or helping the commercial and traders, trade and commerce. So understanding their problems in producing 65B certificate. So he is almost treated as a god in Mumbai. So if you have any chance, go to the YouTube and see the lecture by Nariman, okay, the judge of Supreme Court. Then here again, let's go ahead. A party desiring to produce and prove an e-record who has done everything possible to obtain necessary certificate given by a third party or which has no control, then must be relieved of the mandatory obligation of 65B. Nariman has said, भैया है party है, वो उसके पास e-record है, but this certificate has to be given by third party. That third party is a very big fellow, like Reliance का owner है. So वो देता नहीं है. So what can you do? He has done, he has letter, he has done legal notice, he has given, sent registered post, then he has come to the court and court has issued a summon, but nothing has come out of it. Then what do you do? Then he says such party should be relieved of the mandatory obligation of 65B. No need to give 65B here. Certificate दे दिया बस है, record दे दिया बस है. When e-record is produced by a party who is not in possession of the device is not with you, device is with a very big shot, from which a document is produced, such party cannot be required to produce certificate under 65B. Applicability of requirement of certificate being procedural should be and can be relaxed by court wherever interest of justice so justifies. This is in 2018 judgment of the Supreme Court. What has it said? Important is interest of justice. Important is that this particular 65B is only a procedure. It need not become the entire karta dharta of the entire case. The entire case cannot be thrown to winds just because 65B is not there. Let us say a situation, phone में किया है, phone गया है, phone किसका है नहीं मालूम. We have given that recording in a say party. Okay, and somebody took somebody's phone and somebody shot the movie. Okay, that movie contains vital proof for this murder case. Later on, that cell phone किसी को आ गया किधर गया पता नहीं, but it was shared over the internet and this fellow has taken it. Okay, obtained a copy. Now, if he asks for 65B report, he doesn't even know किसका phone है, with which it has been shot. He has only got it now, he has sent it to himself. So he has got in his phone. So he produces it. In such a situation, when he is not in possession of the device from which the document is produced, such party cannot be required. You cannot force him, or else you will lose your case. ऐसा नहीं बोल सकते, because it will defeat the interest of justice. So then the requirement of a certificate. Next case is requirement of a certificate can be relaxed by the court in interest of justice. For example, suit for recovery of a bank against the borrower. Recovery suit है. Statement of account being a document proved by the Bankers Book of Evidence Act. Then there is no need to go into 65B कौन दिया, कब दिया, कहाँ से आया, whether this particular point of time same computer used, so other computer can be used, because nowadays this statement can be generated by you on your WhatsApp also, or SMS banking also, or internet banking also. Okay, you don't have to go and see and check the banker's computer itself. Earlier that was there. The banker's computer itself will generate the statement, and then the bank manager will sign the 65B and give it to you. But if you generate it yourself from your own computer, cell phone, or your own laptop, and get it printed on you, 65B कहाँ से लाओगे? But if it is there, Bankers Book of Evidence is there, the statement generated without human intervention is there, all the data is there, it is matching, there is no proof, or there is no allegation that the data has been tampered with, then you better use it. You use it for deciding the suit of recovery by a bank against the borrower, and then serve the justice. Don't try to make a procedure here all and end all and be all, and then kill justice. That should not be done. So this is how we have discussed. Okay, the electronic records. Electronic records. We have discussed the 65B and 65A. This is a very, very crucial position. This is a very crucial provision of Indian Evidence Act, which in practice, while dealing with the court, you will be able to really appreciate the importance of what we have discussed so far today. Okay, that's all. Thank you. We'll meet on Monday, because tomorrow and day after there will be no class. Okay, as your people have asked, madam, we'll meet on Monday.
Thank you, sir.
Right. Okay.